Great to
Kandis.
see you again.
Likewise.
So I love when we get together and we talk about current issues in employment law, your area of practice, and intellectual property law, my area of practice. And today we have a case to talk about that actually involves the intersection of our two areas of practice. And it also involves an old friend that we've talked about before, Trader Joe's.
Ah, yes.
So this is a Ninth Circuit case that's come out a few months ago. And as the Ninth Circuit said, this case lies at the intersection of two federal statutes, the Norris-LaGuardia Act under Labor and Employment Law and the Lanham Act or the Federal Trademark Act under IP law. So, but there's a history behind this Trader Joe's intersection of labor and IP. You want to tell me a little bit about the history?
Yeah, there is. You may recall about a year ago, we talked about this a little bit in the sort of Smile, You're at Trader Joe's. Trader Joe's has had a long history of kind of rocky labor relations. Some of the employees have tried to organize, and some employees, in fact, have organized, but there are ongoing sort of labor management disputes. So what happened as sort of the lead up to this case is that the Trader Joe's United Union filed an unfair labor practice action against Trader Joe's.
Okay. With the National Labor Relations Board.
Relations Board. Then, just less than a week later, Trader Joe's filed this trademark
infringement
action. And so, of course, if you are Trader Joe's union, you think, well, the two things are related. You know, we had an unfair labor practice action, and now we're involved in this. So that's where the
retaliation.
It was retaliation.
To use an employment word.
Yeah, it was retaliation, and so that was, in a sense, was Trader Joe's defense to trademark infringement. They said basically, this is a labor dispute, and the Norris-LaGuardia Act precludes the court from entering the relief that Trader Joe's is seeking in the trademark infringement, which was an injunction, because Trader Joe's is using this lawsuit to sort of get back at the union for filing the unfair labor practice.
Right. And
so,
and that's how I kind of first became aware of the case, is, you know, just reading from all my colleagues on LinkedIn. A lot of the IP professionals were kind of outraged by this, you know, in the sense that it did appear that Trader Joe's was using intellectual property law as sort of a tool in its arsenal in the, you know, labor union context, which a lot of folks didn't like.
But this really involves an iconic Trader Joe's product, the cotton tote bag. So tell me about the intellectual property issues related to that, because, I mean, you know, I think if we don't have one, we certainly know people who do, and it's an item we see everywhere. And what did the union do to Trader Joe's cotton tote bag?
Right. Well, Trader Joe's United, which is the name of the union that's being implemented, has a website on which it discusses its unionizing activities, but also sells merchandise bearing the Trader Joe's United name and logo. One of the merchandise items is a tote bag.
Yeah.
So there are other things, buttons, mugs.
All sorts of good things.
As both courts found, so this is coming out of a Ninth Circuit appeal, so which means, of course, there was the district court opinion first, and both courts noted that based on the facts in the complaint, at least, because this, of course, came to the district court on a motion to dismiss on the face of the complaint. So there wasn't a record developed during discovery.
Right.
It was a very early motion to just dismiss the complaint for failure to state a claim that was brought by the union, Trader Joe's United, and they prevailed. The Ninth Circuit then reversed. But both courts recognized that, at least on the face of the complaint, the only items that Trader Joe's and Trader Joe's United sold in common was the tote bag. And of course, because of the iconic nature, I guess that had some resonance with
I think
the
it did. You
Ninth
see-
Circuit
yeah.
for sure.